Okay, hello everyone, and welcome to our webinar today. It is about all the new laws effective yesterday, and we have today Jane Bolin from the firm Peyton and Bolin going to handle the presentations. So I just want to do a little bit of housekeeping. First of all, my name is Peggy West. I'm the organizer, and this is not going to be a CEU credit for today as yet. As soon as Jane can get her certification on this particular class, we hope to get you a credit. Put your questions in the Q&A box down the bottom. If you have a comment, put it in the chat box. And sponsors, if you'd like to put your name and contact information in the chat box for everyone, that would be great. The first hour is going to be on the HOA laws from 12 to 1, and then from 1 to 2 is going to be on the condo laws. Also, I want to say many have asked me about closed caption. If you want to do that, at the bottom of your screen, it says show caption. If you click onto that, it will start printing and showing all of the conversation. I want to get started now by introducing the sponsors. I'm going to start with the IT support, introducing Katie Basford. She's the National Marketing Manager and IT support for Vinteum software. So Katie, can you do a quick introduction, please?
Yeah, hi Peggy. Thank you so much for introducing me. As Peggy mentioned, I work with Vinteum software. The main product that we have is Neighbrs, which is an HOA and condo management software. It's particularly relevant for the topic today because Neighbrs does provide both a public-facing website and a secure resident portal, and will keep your association compliant with any of the upcoming website laws. So if you want to learn more or see a live demo, please reach out to me.
Okay, an honorable mention. I want to mention Beatrice. We call her B. De Silva. She is the queen of marketing at Vinteum, and she's the IT support for today. Next, I want to introduce today's monitor. It's Beth Garcia Swopa. She is the Senior Vice President at Brown & Brown Insurance. Beth, tell us about yourself.
Good afternoon. My name is Beth Garcia Spopa. I'm out of the Fort Lauderdale office of Brown & Brown. I am a senior vice president, going on 33 years insurance experience, 20 years in Florida. So an oldie but a goodie. If there's any issues, which all associations are having these days, that you need assistance with on the insurance side or want to be proactive to your insurance renewal, feel free to reach out. I'm here to help.
Awesome. And thank you for moderating today. Next, I have Nick Brenneman. He's the Regional Account Manager for the Southeast region out of Tampa with Reserve Advisors. Nick, tell us about yourself.
Thanks, Peggy. Good afternoon, everybody. Excited to be here and support this great course. We offer reserve studies and structural integrity reserve studies throughout the state. And this topic is near and dear to our heart. So we've had to stay on top of all of the changing legislation as well, making sure our product and services comply and put our condo folks in the best possible position. So if there's anything that we can do to help, please reach out. And I'm looking forward to a great program today. Thanks for having us.
Awesome. Thank you for joining. Okay, next I want to introduce Diana O'Lert. She's the Business Development Manager at Best Roofing. Diana, tell us about yourself, what you do.
Good afternoon, everyone. Thank you so much, Peggy. Thank you, everyone, for being here. As Peggy said, I'm the Senior Business Development Manager at Best Roofing. Best Roofing for us being in business for 46 years. We cover Palm Beach, Broward, and Dade, and we'll do anything and everything that you need on roofing. So if you even have a question, just, to be more educated about roofing systems, things that need to be done, please contact me. I will be more than happy to help you. But we also do repairs, roof recovery, maintenance programs, you name it. So I'm here for you, and I hope you enjoy the class.
Thank you so much. Next, I want to introduce Ricardo Mancada. He's the Chief Inspector and also the Principal at RMS.
Hello, everybody. Thank you for being here. As Peggy says, I'm Ricardo Moncada with RMS, Building Envelope Consultants. We protect the building owner's best interests when it comes to roofing and waterproofing. We are not contractors like Best Roofing. We're only consultants. We work with companies like Best to provide you with solutions. If you're thinking about a roofing project, please call us ahead of time. Sometimes people start soliciting bids and they call us once they're deep in the woods, and it's harder for us to help you. So if you're thinking about re-roofing, call us first allow us to help you through the process and completing a successful roofing project.
Okay, great. All right, and he's the best, by the way. Next, I want to introduce Suli Encolada. She's with DSS Condo, which is a division of Socotec. She's the Director of Business Development. Tell us about yourself and what you do.
Thank you, Peggy. As Peggy mentioned, yeah, I'm Sulin Calada. I'm the Director of Business Development with DSS Condo. We are a division of Socotec. DSS Condo, we're owner's rep project management company. We offer complete project management. We can help you with your project from beginning to end, making sure your project gets completed on time, on budget, and causing the least amount of stress to your residents, which that's what we all want. We can help you with all these projects you have going on. So anything you need, please feel free to give me a call, and I hope you enjoyed the class today.
Okay, great. Thanks, Suli. Next, I want to introduce Brian Rammel. He's handling the marketing and business development at United Professional Engineering. Brian, tell us about what's going on over there at UPE.
Thanks, Peggy. Appreciate you allowing us to be a sponsor for this webinar. Like she said, I'm with United Professional Engineering. We are a structural engineering firm located in Lake Worth Beach, Florida. We've been in business for a little bit over 18 years. The principal engineer, his name is Carmelo Giglio. He is an alumni of the University of Florida and very accredited. He has every license under the sun, it seems like. And he helped out with the Surfside collapse after the Senate bill needed some help from structural engineers. He is about to be the future president for Florida Structural Engineering Association, and we are happy to be a resource. We specialize right now. We're doing a lot of condominium recertification and milestone inspections. So if anybody has those needs, reach out. And we also have a very thorough process in working with general contractors after analyzing the topic that we're here today, hurricane preparedness. So thank you so much for the opportunity, and feel free to reach out.
Okay, thank you so much. Okay, next I want to introduce Mark Landez. He's the audit and the principal. And I want to introduce Nicole Pendergrass. She's a partner and operations manager at Hafer Company. They are not on today. I'm not sure why, but they are outstanding. They're probably busy doing audits. And they're in 4 cities around the state of Florida. And they will be on the sponsor sheet following these introductions. Next, I want to introduce a longtime contact and friend of mine, Jamie Gelfand. She has just become the Vice President, Regional Sales Officer for Community Association Banking at First Citizens Bank. Jamie, tell us about yourself and what you're doing there.
Thanks, Peggy. First Citizens Bank is a 125-year-old top 20 bank. As your associations are getting ready to collect your CSRS reserves, please be sure that they are all looking to be FDIC protected. We have that ability through CDARS, laddered CDARS, ICS, insured cash sweep. Also, as you're doing your milestone projects, we have a $3 million quick term loan where approval is provided in less than 3 days and you can close in less than 30 days. And then for traditional projects with up to a 15-year term, we are very competitive in the market for that as well. So thank you, Peggy, once again for all the hard work that you put in to put these seminars together, and looking forward to Jane's education this afternoon.
Thank you so much. That was nice. I also want to introduce Gil Schauman. He is with Altieri Insurance Consultants. Gil, I saw you there. Are you coming back? Introduce yourself and what you're doing at Altieri.
Yep. Hi, everyone. Thank you, Peggy. My name is Gil Schauman. I'm a public adjuster with Altieri Insurance Consultants. We are licensed to represent unit owners and condo associations and commercial properties throughout the claims process. So any type of property damage you may suffer day to day, whether it's pipe breaks or fires or large scale natural disasters such as hurricanes, we're here to help guide you through that process, make sure you get paid correctly and in a timely fashion, and make sure that the reconstruction project moves along smoothly without having to dip into reserves, taking out costly bridge loans or charging assessments to unit owners. We also consult on preparedness planning, and we'll review your policies for free. So feel free to give me a call or shoot me a message directly.
Okay, great, Gil. Thanks for joining. I
Absolutely,
count
thank
on, you're welcome. I was holding out for Rudy Forehand to get on because he's usually at the webinars when he's available. But Rudy is the manufacturer's rep and a district manager for Benjamin Moore Paints. And he does an outstanding job of actually visiting the condos with his dealers, and he helps make your selections. So Rudy's information will be on the sponsor sheet following this. And the last thing I want to mention is that I also do part-time work with Beach and Patio Outdoor Living. And right now I know the boards are voting and changing and looking at things. So if I can help you in any way with new furniture, pre-owned furniture, we do repairs, restrapping, and so on. And I'll give you a great deal. So with that, I want to introduce our speaker is Jane Bolin. She's with Peyton Bolin, attorney firm, and she has been for years in this industry. Really a true expert. Jane, I'm going to turn this over to you to say as much as you want.
Let's do it. So I'm going to share my screen right off the bat. So we are going to get started. Thank you to all the sponsors, and thank you mostly to all of our participants. I appreciate you being here. Okay, so first things first. I am Jane Bolin. I'm the owner and founder of Peyton Bolin, which is a real estate and community association law firm. And all I'm going to tell you about me is that I was actually a licensed community association manager before I became an attorney. And so for that reason, I feel like I really look at association law a little differently. And we are about to go into about 90 slides between HOA and condo world. And what I want to do is try to break those things down in words we can all understand. So that is my objective today, and is to help you and to support you in mastering the business of your association and applying these laws in practical ways. So rules of engagement, just really quickly. Again, there's no credit or educational credit or certificates for this webinar. This is a broad view of both the changes to 720 and 718. We will send copies of the slides by Friday. This will be put on YouTube after the fact. Please put your questions in the chat, which is not the chat, the Q&A. I apologize, the Q&A. Of course, I'm an attorney. This does not create an attorney-client relationship, and I cannot give you legal advice. So before taking any actions based on what I'm about to share with you, be sure to speak to an attorney. And if you need support, just let me know. Okay, I'm going to start off with this slide. A homeowners association is not a condominium, and a condominium is not an HOA, and neither one of them are cooperatives. So an HOA falls under Florida Statute 720, which is a very specific statute for homeowners associations, and condominiums fall under 718. We are going to be talking about those two types of common interest communities today. If you don't know what type of community you're in, I actually saw a quick question come up around where do townhomes fall? So townhomes are not their own separate section. They could be a condominium and they could be an HOA. You need to check your governing documents, but words do matter. And I say that to you because people throw around the word HOA like it's what they're paying their assessments when they really live in condos. And so it's really important you get that clear, or else you may be applying the wrong law to your association. And to really give you the visual to take that home, words matter, right? Because on the left is not a Dalmatian, but on the right is definitely a dog with black spots. That is a Dalmatian, right? So two very different things. You need to be clear about what you're doing. All right, HOA law, this is what we're going to start with. There are 6 pieces of legislation we're going to cover today. First is HB 1203, which is really the large HOA reform bill. There's then HB 59, which is the rules and covenants. Then we're going to talk about hurricane protection, energy sources, property rights, and builder warranty. So right off the bat, managers must attend in person at least one board meeting or one member meeting annually. This is actually a change to 468, which is the Community Association Manager Statute, but absolutely impacts HOAs. Managers must provide the members of the association with a name and contact for each management employee that is assigned to the HOA, along with their hours of availability and summary of duties. Now, for some of you, this might seem like you don't do that. You'd be surprised. So it has to be posted on the association website, and upon request, the contract between your manager and your association must be made available. Any changes to the information I just described has to be updated with the members within 14 days of those changes. Now, CAMs overall are going to have 5 hours of education specific to HOAs, and 3 of the 5 hours must be related to record keeping. So that is a new education requirement that just hit and will be required every 2 years. So you may be thinking, well, thank you for the CAM requirements. What about me as a board member? What about that? Well, things have definitely changed. In the past, you had an option to take a board education curriculum requirement or to sign an affidavit. That affidavit is gone. You no longer have that option. 90 days after being elected or appointed to office, you must submit a certification of a completion for a course that's been approved by the department, and it must be done within that 90-day time frame. Board certification was originally 2 hours. It is now 4 hours, and it must include topics including financial literacy and transparency, record keeping, levying of fines, notice and meeting requirements. Directors must complete this course at least every 4 years. So it's not a matter of whether you left and you come back. If you were on the board for 4 years, you must do it every 4 years. If your homeowners association has 2,500 or more parcels, you must have additionally 8 hours of continuing education annually. So you've got to take your 4, and then in a year, you've got to take 8. And then every year you must take another 8. If you have 2,500 parcels or less, it is only 4 additional hours of continuing education. And if you fail to comply with that, you will be suspended from the board until that compliance is achieved, and the board will be able to actually replace you for that time period. I put this note, expect new rules to adapt and implement this section. Absolutely. I would also say to you, you may be like sitting back, wow, that's a whole lot. It definitely is. I would tell you that this HOA reform bill, it really is a result of what happened at the hammocks in Miami. So when I hear about all the education requirements, I think to myself, yeah, that is a response to that. And it's also a response to Eric Glazer. So I want to give him a shout out. Eric Glazer, who does a condominium and HOA radio show, has been talking about education requirements for a very long time. And I very much want to acknowledge him for his hard work with the legislature. Let's talk about websites. So they must be accessible through the internet and include a separate section that is only accessible to owners and employees of the association. Upon written request by an owner, the association must provide the owner with a username, password, and access to those protected areas. They have to make sure that the records that are required by statute are available and that the inaccessible ones are not posted. So what would be not accessible? Well, applications to approve or deny, criminal background checks, etc., would not be information, anything containing social security numbers, etc. If protected information is included in documents that are posted on the website, the association must ensure that that information is redacted before posting to the documents. So I use the word redacted, I actually use the strike through, but the strike through is not a redaction. A redaction is actually that when you see the black marker over the writing, that's redaction. The association is not liable for disclosing protected or restricted information unless a disclosure is made with knowing or intentional disregard of the protected, restricted nature of such information. So you need to be very mindful as a board about this. At the same time, you don't have to be super worried, because if you're not doing it intentionally, you're not trying to cause any harm, you'll be fine. But you need to be aware that these new requirements are in place. Now here, this is really interesting. So notices of any scheduled meeting of the board and the agenda has to be posted in plain view on the website or on a separate subpage that's labeled notices. Now that's always been the case. So 48 hours notice must have an inconspicuous place. But this is interesting. The association is required to post on its website or app any document. So that would be contracts, amendments, proposals, RFPs, you name it. That is going to be considered at the meeting agenda for at least 7 days before the meeting at which such document will be considered. So all of my sponsors who are on this call are probably thinking, oh yeah, I definitely need to make sure that my boards or potential clients are doing this properly. Absolutely. And boards, you want to be sure you're doing this properly. So it is very new to have that requirement for the attachment. Now, more website requirements. By January 2025, associations with 100 or more parcels must post, really, this is the official records on your website or mobile app. So I'm not going to read each one of these. This is actually the official records that are listed in the statute. Again, you're going to get a copy of these slides, but you need to be sure that all of your documents are there. And I would say to you, the idea is to think about transparency and the ability for anyone to see the documents that are being discussed and used in day-to-day business of the association. And this list actually goes on to the next slide. And you will notice the bottom note, I do want to read that out to you. So any contracts or transactions between the association and any director or officer, company or other association not affiliated that may be deemed a conflict of interest or that there is a financial interest absolutely has to be disclosed and absolutely has to be on this list. So this is incredibly important that you understand that this is required and that your websites will need to have all of that information. So sort of in the same theme around official records. So the records of the association have to be maintained for 7 years unless your governing documents require longer. That really is a clarification. It really has always been 7 years, but they just made it very, very clear. But this is a note right here. So for all of the boards that are listening and CAMs, right now, associations must adopt a document retention policy, setting forth the method or policy by which official records are to be retained and the time period that they must be retained. Now, you may be thinking, why do I need a policy if this is what the statute requires? Good point. Your policy may reiterate what's exactly in the statute. It may actually defer to the statute and say official records under 720, and they will be maintained for a certain amount of time. But I think you actually take it a little bit longer and you say to yourself, what does that retention policy actually look like? As in, is management responsible for it? Is it in a Google Drive? Like how are you actually keeping those records? I think is critical. And that policy actually has to be made available to the owners as well. And then there's one more little thing that was listed very clearly in the statute, which is official records requests are now clarified to be limited to requests from parcel owners. And I thought that was just an interesting addition. A parcel owner could still use a power of attorney and provide that to somebody to attend, but the request itself must come from the owner. Now let's talk about the criminal sanctions. So again, there's you'll see a lot more of these throughout these updates. A member of the board, association, or manager who knowingly, willfully, and repeatedly violates the rights of owners to inspect records with the intent to cause harm to the association or one or more of its members commits a misdemeanor of the second degree. So I really feel like this is a very stringent provision because it is making it very clear records are available. They should be open and transparent. And if you're willfully and repeatedly not providing them, it's going to be an actual crime more than just a punishment from DBPR, or actually Division of Condominiums, Timeshares, and Mobile Homes. The term repeatedly means 2 or more violations in a 12-month period. So any person who knowingly or intentionally defaces or destroys accounting records during a period in which such accounting records are required to be maintained, which is like 7 years and always, and who knowingly or intentionally fails to create or maintain accounting records with an intent, again, to cause harm, commits a misdemeanor of the first degree. So it's a little chilling for board members to see this and it'd be like, oof. But I would give you some solace in the idea that intent to cause harm, it's pretty broad, and they're going to have to prove that you actually intended to cause harm. And I think, 99% of our boards and our HOAs are all doing the right thing. This is very much a response to the 1% that was not doing the right thing. Any person who refuses to release or otherwise produce association records with the intent to avoid escape, detection, arrest, trial, or punishment for the commission of a crime, or to assist another person who's trying to do that, they commit a felony of the 3rd degree. And if an association receives a subpoena from law enforcement, they've got 5 days to respond. And there's an affirmative obligation on behalf of the association to assist law enforcement in its investigation to the extent permitted by law. So again, this is a Hammocks response, in my opinion. And I will tell you, I have rarely seen law enforcement reach out. I think in all of my years, I've had it happen once where I've had actually an investigation. And of course, we were very willing to provide information, but it's interesting because we didn't get information back. So the point being, look, you got to comply. If law enforcement comes to you, you help. And if you're unsure about what's happening, speak to your attorney and ask them about public records requests to find out why an investigation has been started. Okay, financial reporting. Associations with at least 1,000 parcels must prepare audited financial statements regardless of your total revenue. So let me pause, take you back. Currently, with your financial reporting requirement, which is a requirement to provide financial reporting within 90 days after the end of the calendar year, is based on revenue. Now, there's a new requirement based on the number of parcels that says it is based on 1,000 parcels must have an audit. All of the other levels still exist, but this means anything with 1,000 more parcels must have an audit. Associations may still provide those lower thresholds of financial reporting upon a vote of the majority of voting interests at a properly called meeting of the association. But this lower threshold may not be implemented for consecutive fiscal years. So if you have there's the audit, and there's the compiled statements, and then there's the sort of books and records statements. If you want to go from compiled to a lower amount, you cannot do it every year. You can say, yep, this year we're going to do that, but we can't. When it comes to audit, if you're $500,000 or more and you're in the audit space, but you're not 1,000 parcels, you could say this year we're not doing an audit. Next year we have to do an audit because we can't do it consecutive. If you're at 1,000, you're always going to have an audit. And that's how that works. Okay. This is interesting because it's something that happens a lot for association boards where they feel like they're being harassed by unit owners. When a parcel owner makes a written request for a detailed accounting of any amounts owed to the association related to that parcel. So this is not a general accounting. This is, I'm Jane Bolin, I own unit 101, parcel 101, and I want to know what the accounting is that you're saying I'm late for or what that may be. I can make that request, and the board is required to provide that information within 15 days of the written request. After I make that written request, I must wait another 90 days before I can do it again. So that gives you some buffer zone there, but you need to be very aware that failure by the board to respond to a written request for a detailed accounting constitutes a waiver of any outstanding fines of the owner who requested such accounting with respect to fines that were owed more than 30 days past due and for which the association did not give prior written notice of the imposition of such fines. So it is an interesting new provision. I think normally when we think about records requests, you immediately go to 10 days, official records 10 days. Here, you need to think if a unit owner is asking for an accounting on their unit, you've got 15 days to respond, and they can only do that once within 90 days. And really all you need to remember about the third paragraph is that there are consequences if you don't do that. And that's what's important. Debit cards. Okay. So don't use debit cards. It's probably the place to start, but it doesn't say you can't always use debit cards. So an association or its officers, directors, or employees and agents may not use a debit card issued in the name of the association or billed directly to the association for the payment of any association expenses. A person who uses the debit card issued in the name of the association or billed directly to the association for any expense that is not a lawful obligation of the association is deemed to have committed a theft. Now, here's the caveat. The term lawful obligation means an obligation that has properly been pre-approved by the board and is reflected in the meeting minutes or written budget. So that's what you need to remember here. Don't use a debit card unless that use was pre-approved at a duly noticed meeting and is in the meeting minutes. So the statute doesn't say don't use debit cards. I'm telling you, boy, that would just be easier, right? Like just way easier. But you still have the opportunity to do that if you follow what is defined as lawful obligation. Okay. Finally, interest. So if no rate is provided in the declaration or bylaws, simple interest accrues at the rate of 18% a year. So this is already the 18% has already been in the statute, but the change in language is actually quite specific. They say simple interest accrues at the rate of 18% per year. And then it goes on to say, regardless of any provision of the governing documents to the contrary, no compound interest may accrue on assessments and installments that are not timely paid. So simple interest, and I'm just going to explain this. Simple interest is interest that is annual interest rate on one amount, okay? Compound means every time the interest is added, it goes to the principal balance, and then the principal balance increases and interest is added again. So managers and boards, take note of this. It seems like a simple slide, but you want to ask the question, how are we calculating the interest in our HOA? Because I promise you, many have been doing it the compound method. Okay. Fiduciary duty. The board may rely on information, opinions, reports, or statements, including financial statements and other financial data, if prepared or presented by one or more officers of the employees of the association, whom the director reasonably believes to be reliable and competent, legal counsel, public accountants, or other persons as to matters the director reasonably believes are within their professional expertise, or a committee appointed by the board of which a specific director is not a member if the director reasonably believes the committee merits confidence. So why does this matter? It's basically outlining for you what the board may rely on, because we use a reasonable person standard when we talk about fiduciary duty, same and similar position, board members as volunteers. But this says board members may rely on this information when executing their duties and to keep them within the fiduciary duty realm. But what's not in the fiduciary duty realm is definitely kickbacks. And we have been finally able to just put this in black and white and in the statute. So an officer, director, or manager may not solicit or offer to accept a kickback. They have defined a kickback as anything or service of value for which consideration has not been provided for the benefit of that person or their immediate family or someone else who's proposing those to sell those or provide those products or services. An officer or member, officer, director, or manager who knowingly solicits, offers to accept, or accepts a kickback commits a third-degree felony and is subject to monetary damages. So that's a serious offense. And if the board finds that an officer or director has received a kickback, the board must immediately remove the officer or director from office and fill the vacancy according to law until the end of the officer or director's term. So again, I definitely think this is a response to very specific events, but I'm also very pleased that it's just really black and white. No more kickbacks. And a thing of service or value can be that your lawn gets cut one more time than the other members of the association, or that they decide to cut hedges only once a quarter, but your hedges get cut every month because you're the president of the association. Does not work, is absolutely a kickback, and will result in you having a felony of the third degree. Okay. Removal from office. So if you're charged by information or indictment for forgery of a ballot envelope, voting certificate used in an election, if you're charged with theft or embezzlement involving the association's funds, destruction or the refusal to allow inspection of official records of the association, within the time periods required by law in furtherance of a crime, obstruction of justice, or any other criminal violation set forth in the statute, you must be removed from office and a vacancy declared. When a vacancy is declared, then the board can actually replace you. So removal from office is just, it's a mandate now. If you find yourself being charged by information or indictment. Okay. Not a lot of fun subjects there, right? Let's take a quick break just for 1 second. Are there any questions related to what I've just gone through that we can maybe pop up? And
Yeah, there are actually a lot of questions that have come in.
Fun.
So exactly what information about the CAM needs to be on the HOA website?
So it's what I had on the first slide. It's the person. So it's the CAM, it's their name and their contact information, the hours and their duties. When we send the slides, and if I've already had it on there, it'll provide it for you, but that's what has to be there.
Okay. Can a presenter give a concentrated 2-hour course and then give a credit for 4 hours of certification?
No,
think
it's
you-
gonna have to, I mean, I'll let you know this, the department will accredit us for 4 hours. We've got to do 4 hours. No way. Yeah.
Can you go over the truck parking? I have read articles that there's an issue as to it's retroactive to HOA association.
I'm
that
about
have
to get into
vehicles-
that part. So we're gonna
Okay.
hold on that. Architectural control is up next.
Okay.
Okay.
When an owner of a condo brings in another person to live with them and calls that person their guest, how long is that person considered a guest as opposed to being a tenant?
So we're talking about HOA law right now and not condos. I'm just gonna say that it's not a problem. Just want to make sure everyone knows we're talking about HOA law. And in a condominium, a guest is defined based on what the governing documents say. Can't answer that. That's one of those legal advice questions, but your governing documents is where I'm gonna tell you to go.
Okay. Related to non-first responder vehicles such as wrapped business cars, trucks that don't meet commercial definition outlined.
About to get in
C.
there right now. So we're just
Okay.
about we're close. Don't worry.
Regarding updating the community, how does one go about that? Is mailing required?
Yeah, so that's a very good question. If people have consented to receive electronic notice, you can send them things electronically. If they have not consented, you are going to need to mail it to them and have an affidavit of mailing.
Okay. HB 1203, this is a CAM responsibility, not a HOA. Can HOAs be self-managed?
Of course, HOAs can be self-managed, but these laws apply to you too.
Okay.
So, I mean, you know, of course you can be self-managed, but you are still subject to 1203. And of course, the section around the CAM requirements isn't going to impact you because you don't have a CAM, but yeah, you're still required to follow them.
I talked about CAM info being on the website. What happens if they do not have a website, just a management company portal?
The association is required to have a website. So you're going to have that. And if there's any question about that, and you can use a third party vendor, you're going to need to have certain amount of access that's required. But you're going to have to talk to your attorney just to make sure it meets the statutory requirements. And I'm sure all CAMs are going to look at what they're providing. I mean, every management company has had portals for a long time. Whether they can have a public facing portion and then a restricted portion is the question, because mostly those portals are just restricted portions and not public facing. So I think at least as I hear in the industry, people are figuring that out.
Okay. Since the law became effective yesterday, do they apply 90 days from July 1st? What's the deadline to apply for this rule?
This applies now, July 1, effective July 1.
What if we just got our 2-year renewal? Are we good until for the next 2 years, being that I take 3 hours in the next 2 years? Is that okay?
I'm going to send you the statutory language, but you're going to need to take the other 2. And I believe you're going to have a year to do it.
Okay. So I think you kind of just answered this one. It says, if we already done our training, do we need to retrain in the next 4 hours?
Yep. You're going to, that continuing ed requirement definitely kicks in, whether it's 4 or 8. And if you took a 2 before this, I believe you're going to need to take the 4-hour requirement. And there's a specific date, which I believe is going to be within 1 year, but I'll triple check myself on that. And when we send out the slides, and I'll just make a note of it, I'll address that very specific question for 1203. Okay.
Okay. There's 9 more questions.
We're going to have to hold there because I got to keep going.
Okay. That's why I let you know.
No, thanks, Beth. I think also what we'll do is I will get a transcript, hopefully from Vinteum, of all the questions, and I can consolidate them. And so Peggy, when we send out the recording with the slides, let me make sure we address some of them, maybe, overlapping, right? So let's do that. Okay, great. Let's keep going.
I will forward all of them to your email. Don't worry. I will forward all of them for you and the ones that are received by email.
Okay, great. Thank you. Okay, let's go on to architectural control because there's a couple questions right off the bat about that. So where a board or any ARC committee denies a parcel owner's request or application for construction of a structure or other improvement, the board or committee must provide written notice to the parcel owner stating with specificity the rule or covenant which the association or committee relied on when denying your architectural design request, and the specific aspect or part of the proposal that does not conform to such rule or covenant. Again, you may be thinking, well, that sounds like common sense. It sure does, but many people didn't do that. And it created a lot of frustration because they could not amend their applications to send them back in. So any board or architectural committee of association may not enforce a covenant, rule, or guideline that, one, limits or places restrictions on the interior of a structure that is not visible from the parcel's frontage or an adjacent parcel, an adjacent common area, or a community golf course. Two, requires the review and approval of plans and specifications for central air conditioning, refrigeration, heating, or ventilating if such system is not visible from the parcel's frontage, adjacent parcel, adjacent common area, a community golf course, and is substantially similar to a system that is approved or recommended by the association or the committee thereof. The clarification that describes the association's ability to restrict parcel owners from installing, displaying, or storing any items on the parcel which are not visible from the parcel's frontage or the adjacent parcel applies to items which are not visible from the adjacent common area or community golf course. And then this is this is going to hit you. These items include, but are not limited to, artificial turf, boats, flags, vegetable gardens, clotheslines, and recreational vehicles. Again, you probably have some of these in your documents or in your rules, and the language you're going to need to amend has to do with where they're visible from. So you can't just say we're banning clotheslines forever. It's just where they are visible from. Now, for the questions that were asked, parking restrictions. So you may not prohibit an owner, tenant, guest, or invitee of the property owner from parking their personal vehicle, including pickup trucks, in the owner's driveway or in any other area at which the owner, tenant, guest, or invitee has a right to park pursuant to applicable state, county, and municipal regulations. Governing documents may not prohibit an owner, tenant, guest, or invitee from parking their work vehicle in their driveway, regardless of whether the vehicle has official insignia or visible designation, so long as it is not a commercial vehicle as defined by Florida Statute 320. And in my response, for those of you who are typing right now, what is Florida 320? I will put that in the written response so you can have it clear. Associations may not prohibit owners from operating a vehicle that is not a commercial vehicle in conformance with state traffic laws on public roads or rights of way or property owners' parcels. Where this really hits people is where the prohibition has been around your wrapped trucks, wrapped cars, your, if I had a Peyton Bolin law firm car, it probably would have been restricted prior to this, no longer. So that's a massive change. Additionally, associations may not prohibit first responders from parking their assigned first responder vehicle in the area where the owner, tenant, guest, or invitee otherwise has a right to park, including public roads and rights of way. Associations may not prohibit owners from inviting, hiring, or allowing entry to contractors or workers onto their property simply because the contractor or worker is not on the association's preferred vendor list. Associations are prohibited from precluding owners from using contractors or workers on their property because they do not have a professional license. This is very different than a condo, but in an HOA, you won't be able to stop them at the guard gate and ask them for their license. Association may not require a contractor or worker to provide a professional or occupational license as a precondition to entry to work on your home. So that is a massive change. And I think there are some associations that may not do anything with this, but I definitely know other associations that have used their security services to prohibit vendors from coming into the community and to ask these very specific questions. Finally, an association may not levy a fine or issue a suspension for leaving a garbage receptacle at the curb or end of the driveway within 24 hours before or after the collection date or time, and leaving holiday lights or decorations on longer than indicated in the governing documents, unless such decorations or lights are left up for longer than 1 week after the association provides written notice of the violation to the owner. So a couple things about these prohibitions. Certainly I know there are people on this call that have heard of Kaufman language, which basically says that your association is subject to the statute as it is amended from time to time. You should speak to your association council to determine if you are subject to this, if your declaration of covenants and restrictions has Kaufman language or not. And that is absolutely a legal decision and discussion between you and council. But right now, I would tell you this is a major change to what associations can actually restrict. So let me take you, now that we talked about a bit the fines and the restrictions, where does that really take you naturally is fine and suspension procedures. So a fine or suspension levied by the board cannot be imposed unless you first provide 14 days notice with a right to have a hearing. And the difference here is that they may attend the hearing by telephone or other electronic means. So that's always been the case, and now it's clarified for that. The committee hearing must be held within 90 days after issuance of the notice before at least a committee of 3 people who are not officers or directors of the association or otherwise spouses, family members, etc. Again, that may be held by telephone or electronic means. And the committee hearing notice must include the description of the alleged violation, specific action required to cure such violation, and the hearing date, location, and access information if held by telephone or other electronic means. So it's similar. I mean, we've always had the 14 days notice, but the committee of 3 has always been the same. The key is that the hearing has to happen now within 90 days of that original violation, and that you've got the opportunity to attend. So I've had in the past people have to fly in from out of, Canada, wherever, to come to a hearing. It seems absurd, and that's now been changed. Within 7 days after the hearing, the committee has to provide notice to the owner and potentially the occupant or invitee or licensee, whoever's related in that violation, about the applicable fines and or suspensions, whether they were approved or rejected, and how the parcel owner can actually cure the violation or fulfill the suspension or pay the date. So again, more specificity than we've had in the past, very similar to what's been there. If a violation's been cured before the hearing, so this is major difference, or in the manner specified in the written notice set forth the post-hearing results, a fine or suspension may not be imposed. If the violation is not cured and the proposed fine or suspension levied by the board is approved by the committee must set a date by which it must be paid, and it must be at least 30 days after delivery of the notice. So we've definitely had situations where people have cured the violation, the fine committee has continued, and that basically comes to an end now. Attorney's fees and costs may not be awarded against parcel owners based on actions taken by the board before the date set for the fine to be paid. So that's a chilling effect right there. And if a violation and the proposed fine or suspension levied by the board is approved by the committee and the violation is not cured or the fine is not paid, then reasonable attorney's fees and costs may be awarded to the association in a subsequent legal action. However, those legal fees may not begin to accrue until the date notice for the payment and time for the appeal is expired. So in the past, I would say as an attorney, we've done a lot with supporting fine procedures, hearings. Those fees and costs cannot just be shifted over to the owner. You notice it says subsequent legal action. So at this point, the fine has been levied. They did not pay it. We've moved forward. We're now going to take legal action to get this done. We can then seek it there as reasonable attorney's fees, which, side note, means not the actual number on your bill. It means what the judge decides to award as reasonable attorney's fees. Okay. Let's talk about criminal impact. So we talked a little bit about that with voting fraud, but I would tell you the first degree misdemeanors are separately articulated. So knowingly aiding, abetting, or advising a person in the commission of a fraudulent voting activity related to association elections, agreeing, conspiring, combining, or confederating with at least one other person to commit fraudulent voting activity, having knowledge of fraudulent voting activity, and giving aid to the offender with the intent that the offender avoid or escape detection. So really, what you should take away from this is probably a very good person is just don't commit voting fraud. If you have any question about whether you working with somebody else to get votes or proxies may be seen in that manner, I would definitely speak to an attorney about that. There's definitely some confusion in the world about who can collect proxies and how that all works. I'm not going to get into it now, but I'm going to tell you if that's how you're going to approach an election, which is okay because it is an election. Just make sure you get legal advice on it first. Clarification, owners may consent to online voting electronically or in writing. So that actually might seem like, oh yeah, well, that makes sense. But before, you couldn't consent to online voting electronically. It only could be in writing. So that's actually a major change. Okay, I'm going to move very quickly. That was just the first of 6 statutes. So HB 59 rules and covenants. Take note, all HOAs must provide a copy of the association's rules and covenants to every member by October 1st. And this can be done both physically or a digital copy. You have to provide this to all new sales or transfers. If any of your covenants or rules are going to be amended, you have to provide a copy of those amendments to all members. And I would say adopt a policy for the manner and distribution and timeframe for that. To comply, you must post a complete copy on the homepage of the website or direct link on the homepage, and notice to the owners must be sent to identify that the website will be used for this purpose. This notice can be sent again electronically to those who've consented. So bottom line, by October 1st, you guys need to resend all of your governing documents to your members and come up with a policy on how you're going to deal with that when you have amendments. So hurricane protection, this is HB 293. All Florida HOAs must adopt hurricane protection specifications for each structure or other improvement on the property. Specifications may include color and style and any other factor deemed relevant by the board and must comply with Florida building code. The Architectural Control Committee or board may not deny an application for installation, enhancement, or replacement of hurricane protection that confirms with these adopted specifications. They may require an owner to adhere to an existing building aesthetic regarding external appearance of hurricane protection. Hurricane protection defined is roof systems, permanent fixed storm shutters, roll down storm shutters, impact resistant windows and doors, polycarbonate panels, reinforced garage doors, erosion controls, exterior fixed generators, fuel storage tanks, and other products used to preserve and protect structures and improvements. So here's, on top of the other notes you've taken, the other note you need to take now is we need to adopt specific specifications regarding hurricane protection in our community. And if you have an aesthetic you want to keep, you've got to take note of that and make sure that that is part of what you have. And remember that you can't deny it just because you don't like it. However, you could require that they comply to the aesthetic. So it's a little nuance with that because you can't deny it outright, but at the same time, you can command that it meets the certain look. So just do me a favor, sit down with your attorney, look at hurricane protection. There's probably some of our vendors actually here on this webinar that can support you in talking about the different kinds of hurricane protection you have, from roof systems to storm shutters. Okay, energy sources. So this is very interesting. So associations governing documents may not prohibit the types or fuel sources of energy production that may be used to deliver, convert, or supply by the following entities. So public utilities, electric utilities, entities, etc. Basically, governing documents may not prohibit the use of an appliance, including a stove or a grill, which uses fuel sources and different energy production methods that are used, delivered, or converted and supplied by the entities above. And the term appliance means a device or apparatus manufactured and designed to use energy for which Florida Building Code or the Florida Fire Prevention Code provides specific requirements. So I thought about this slide for a long time and I was trying to think about how to explain this. I don't think we're going to see this be an issue until it becomes one. I think this was an anticipatory change based on the change in energy and how, frankly, FPL and our utilities are working. So we'll see how this one plays out. I almost thought to myself, do I even talk about it? But I do want to make sure it does apply to you and would be part of your legal update. Okay, squatters' rights. This is very interesting, and I think anybody who owns property should know this. There is a new procedure for property owners to request that a sheriff's officer remove an unauthorized person from residential real property. So the property owner must contact the sheriff and file a complaint under penalty of perjury, listing relevant facts that show that they're eligible for relief. Those relevant facts are those bullet points. And it basically says that you're requesting it, and you're an authorized person to do so. The property is residential. There's an unauthorized person there. The real property was not open to the public at the time that the person entered. The owner has directed this person to leave. You must show that you've directed them to leave. The unauthorized person are not current or former tenants pursuant to written or oral agreement. And the unauthorized person is not an immediate family member, and there's no pending litigation. So it is very useful that we have this new way to remove squatters, but those last 3 bullet points are generally where people feel, you have a holdover tenant, you have a family member in there. But if you have true squatters, this new legislation will support you. I will say the one thing that's important about this is if you're eligible for relief and the sheriff removes the person, the property owner must pay the sheriff the civil eviction fee plus an hourly rate if they stand by. If a person is wrongfully removed pursuant to this statute, they have a cause of action against the owner for 3 times the fair market value of the rent, damages, costs, and attorney's fees. And the reason they do this is because they don't want someone to weaponize this. Finally, there's 3 new causes of action in this statute regarding property rights. So 1, a person who unlawfully occupies, detains, or trespasses and causes more than $1,000 in damage commits a felony of the 2nd degree. 2, making a false statement or providing a false document and purporting that it is a valid lease, deed, or other instrument is a misdemeanor. A person who lists or advertises property knowing that the seller has no legal title or authority or otherwise rents the property with that same knowledge is now committing a felony. So we have had a rash of property issues in the state of Florida. And I think this is a very strong bill to support us. Okay, and the last slide for HOAs, I got right in under the clock, is builder's warranty. So this is a new statute. Builders must warrant homes for all construction defects of equipment, material, or workmanship provided by the builder and any subcontractors or suppliers for 1 year after the closing or date of initial occupancy, whichever occurs first. This warranty can be transferred to subsequent owners in that 1 year period. It doesn't extend the 1 year period, it's within that period. It does not apply to appliances or equipment that has its own manufacturer's warranty. Doesn't apply to normal wear and tear, house settling, construction, modification, or repair work performed by the initial purchaser to the extent the work was not performed by the builder. So like if you went in and made those changes, damage caused by the purchaser themselves or acts of God. Builders may fix defects at their own expense or purchase a warranty from a home warranty association to comply with this statute. Okay, woo! We're 1 minute under for condos. To get a condos.
Well, yeah, so I'm going to say to everyone's asked questions, there are a lot of great questions in here. That there are 45 open. So Jane will send an email out addressing all of those.
Yeah, I'm sorry. I knew that this was a high level review and that there was a lot to put in there. And we'll just have to do the questions by email. That's just what we're going to do this time. All right. Thank you.
Yeah, great information, Jane. Really good stuff.
Okay, great. Whew. So this is my last slide to end the HOA world, and we are now going to shift over to condominiums. Just give me 1 moment. Okay. All right, we're resetting. Welcome to the 1 o'clock webinar now to talk about condominium changes. Again, this is a 30,000 foot view. This is not for credit, but we are going to be talking about 3 different statutes. HB 1021, which has fondly been dubbed in the media as Condo 3.0. HB 1029, which is the My Safe Florida Home Condominium Pilot, and then property rights, which I actually just spoke about, which applies to both condos and HOAs, but I'm going to run it again because we know that we have people coming in. So if you're new to the webinar, thanks for coming. We appreciate it. There's no credit or certificate for this educational webinar. Copies of the slides will be sent by Friday. We are having an overwhelming number of questions. I'm going to probably do what I did in the last hour, take a stop because I just need to myself and I'll answer a couple questions, and then we'll answer all the questions via email at the end. This webinar does not create an attorney-client relationship and no legal advice is being provided. Please seek the guidance of an attorney before taking actions. For those of you who don't know me, I'm Jane Bolin. I'm the owner and founder of Peyton Bolin, which is a real estate and community association law firm. And my one fun fact is I was a licensed CAM and owner of a management company before I became a lawyer, which has me definitely look at the law in a very different way. Okay, let us get started. Condominium law. So the definition of condominium has been updated, and it is defined as the lands, leaseholds, or improvements, or any personal properties and easements and rights pertinent to, regardless of whether they're contiguous, which are subject to condominium ownership. The new definition actually removes a requirement that the improvements, easements, and rights would be intended for the use in connection with a condominium. So it's taken that out because it requires, obviously, as you can imagine, what does intended for use mean? So it's taken out that ambiguity and just redefined condominium property outright. There are new hurricane protections. So hurricane protection first is defined as hurricane shutters, impact glass, code-compliant windows or doors, and other code-compliant hurricane protection products used to preserve and protect condominium property. A new requirement is that the declaration of condominium for both residential and mixed-use condominiums must include a statement that specifies whether the unit owner or the association is responsible for the installation, maintenance, repair, or replacement of hurricane protection that is for the preservation and protection. So that, I mean, if you're taking notes and what am I taking back to do, that is an action item right there. There's also a major clarification. So as you know, in condominiums, whenever we make any change, there's always this question of, is it a material alteration that requires a vote of the owners? There is now clarification that the installation, maintenance, repair, and replacement of hurricane protection is not a material alteration or substantial addition to the common elements. So that is a very, very good clarification. Is the vote of the owners required? So a vote of the owners is required for the installation of hurricane protection, and it must be set forth in a certificate attesting to such vote and include the date that the hurricane protection must be installed, of which must be recorded in public records of the county where the condominium is located and thereafter mailed or delivered to unit owners. Such a vote is not required. Okay, so you do need a vote requirement, but it's not required if the association, not the unit owners, is obligated to install, maintain, repair, or replace hurricane protection or exterior doors or windows in the declaration. So if the association is responsible for those things, no vote is required. If the unit owners are responsible for it, a vote is required. What if it was previously installed? Well, if the hurricane protection was previously installed and in compliance with the building code at that time, then the board is prohibited from installing the same type of hurricane protection or require owners to install the same type of hurricane protection unless the installed hurricane protection has reached the end of its useful life or unless it is necessary to prevent damage to common elements or a unit. Okay, we are in hurricane time right now. If hurricane protection must be removed or reinstalled to perform maintenance, repair, or replacement of other condominium property or association property, the association rather than the unit owner would bear the cost for such removal and replacement. That's very clear and was not clear before. The board of the association must determine whether the association or the unit owner is obligated to remove or replace the hurricane protection. And if the association is obligated, it may not charge the owner for such costs. However, if the unit owner is obligated, the association must either reimburse the owner for the costs or apply a credit toward future assessments in the amount of the cost to remove or reinstall hurricane protection. While I am very thankful for these new changes, I am a little nervous about this credit for future assessments. So if you get yourself in that position, please do speak not only to your attorney, but also your CPA. You need to make sure that there is a way to track that moving forward. And I would say definitely board meeting minutes and have it in the official records. Anytime we do that sort of future-based assessment, it needs to be super clear. Okay. So there was a time when this was a hot topic, and it still is. It still is, because everyone's assessments are going up, that's for sure. But there have been a couple tweaks. So first, structural integrity reserve studies have to be included in the turnover inspection report when control of association is transferred. So that wasn't clear before, has to be done prior and must be turned over. Within 45 days of receiving the SIRS, the association must distribute a copy of the study to each unit owner or deliver a notice to each unit owner that it's available for inspection and copying upon written request. So what's interesting about that is it's very similar to the financial reporting requirement, where you have 90 days to give them the same sort of notice. So there are a lot of associations that do this notice like a postcard, and they just say, hey, notice is available. Let us know if you want it, and here's where it's available, versus sending out the full report. The association must send a statement to the division confirming completion and availability of the study to the owners using a form, which the division will put forth. And I think that should be happening very soon. And then by January 1, 2025, the division is tasked with creating a database of associations that have completed this. Now, I've had some interesting conversations and received some emails where people have said, how are they going to do that? Well, it's going to take some time for compliance. And I do think that as we go through this, you're going to see the division has a lot more powers, and a lot of money has been authorized to the division this year. They have 60 plus new employees. I think we're going to see the division look very, very different to the division we've had in the past. Finally, a majority of the board may vote to pause or reduce contributions to reserves or reserve funding if a local building official deems the entire building uninhabitable due to a natural emergency. So a natural emergency means something that's caused by a natural event, including but not limited to hurricanes, right? So that's what's going to impact us, or floods. And the association must immediately resume their contributions if and when the building is deemed inhabitable again. So this is just like a little loophole provision for condominiums. I find it quite interesting that they put it in there, but I can see the scenario happening. Okay, statute of repose. What is that? So think of a statute of repose like a statute of limitations, in that it terminates legal rights if they're not acted upon by a specific time. So this has been added, that the statute of repose for any actions in law or equity which have a condominium association or a cooperative shall have, sorry, I see a typo in there, my apologies, shall not begin to run until the unit owners have elected a majority of the members of the board. So that is when the statute of repose will begin. And really, this is much more applicable when you're looking at construction defect and construction issues. And so certainly when you speak to your attorneys for that, they're going to be well aware of it, but it's something that you want to know is there's a new limitation. And now we're going to get into the business of the association. So what you need to know about the law, then how it's going to impact you as a director, officer, or manager. So meeting requirements for the board. If you have more than 10 units, you must meet at least once each quarter, and the meeting agenda must include an opportunity for members to ask questions of the board at least 4 times a year. That must happen. The right to attend the meeting has been further defined as including the right to ask questions regarding construction or repair projects, status of revenues, expenditures for the fiscal year, and other issues affecting the condominium. So in the past, unit owners have always had the right to attend meetings. They've always had the right to speak, but this is making it super clear that owners have the right to ask these questions. There's been, I think, feedback to legislators about the fact that boards have shut down members when asking these questions. And so they just made it super clear that members have the right to ask these questions, and that you must meet at least 4 times a year. So the meeting requirements for the board. So if a regular or special assessment is going to be brought up against unit owners, then the notice for that meeting has to state that the assessments will be considered and provide estimated costs and the description and purpose for such assessments. In the event that an agenda item of the meeting relates to approval of a contract for good or service, the association is now required to provide a copy of the contract with the notice of the meeting, and the contract must be made available for inspection upon written request by an owner or on the association's website. So again, folks, many years of 48 hours notice in a conspicuous place with a whiteboard that says we're having a meeting at 6 o'clock and here's this like limited agenda is over. You are going to need to have a place where you can actually include the contracts, which most likely will just be on the website. But for some associations who I've spoken to, they still like to do it the old school method, which is fine. You're going to need to be able to make sure that everything is available. So, you know, if you imagine like getting onto an elevator that everybody uses and they have the meeting notices in there, meeting notices plus the contracts, all available. Okay. How to suspend voting rights. So to suspend the voting rights of a unit owner or a member that is delinquent in the payment of a fee or other monetary obligation, the association must first notify the owner at least 90 days before an election that their rights are being suspended. Why do you think they did this? I'll tell you why. Because without this directive, they would suspend voting rights right before the election or right before the amendment vote. And generally that's because an attorney or CAM would say, hey, have we suspended any voting rights? What's going on? Is anyone past due? So now they're just making it super clear. So I think, in my opinion, the best thing to do is if you were going to suspend the voting rights of members for being delinquent more than 90 days, you should just make that like an ongoing rhythm at your board meetings. So it's not being done because you have an election or because you have something coming up. It's just like every 90 days we look at it and we're going to, you know, rolling suspend, and you may look at it every month. Up to you. Okay. A unit owner can now electronically consent to online and electronic voting, which is a good thing because before they could only do it in writing. And if a board authorizes online voting, it's required to honor a unit owner's request to vote electronically at all subsequent elections, unless a unit owner opts out of online voting altogether. So it's not just a online voting for one particular thing, it's for all voting moving forward. Okay, financial reporting waiver. So a condominium association may not waive the financial reporting requirements for consecutive years. So again, financial reporting requirements are annual in basis and are based on your revenue amounts, your total operating plus reserves. So if you are required to have an audit, you cannot waive it down to compiled financial reports every year. You're going to have to do it every other year, essentially. Any vote by the majority of the members to reduce financial reporting must occur before the end of the fiscal year and is only valid for the fiscal year in which it's taken, which is a very good clarification. So the division of condominiums, timeshares, and mobile homes, which I mentioned previously, if they receive a complaint, they are obligated to monitor the association's insurance coverages and may issue fines and penalties for failure to maintain insurance policies or fidelity bond. I cannot tell you how many calls I've had about associations not having insurance, choosing not to have windstorm, etc. I am sure that Beth on this call is thinking, yep, that's an issue. But what this means is the division has now new jurisdiction and they're going to monitor this. How they're going to do that, what fines may be issued and penalties, we've yet to see. That they're going to give us that information as time progresses. But I mean, this is a major change in terms of their jurisdiction. So everyone that's listening, if you don't have insurance or you've decided you don't want the fidelity bond because you don't think it's too expensive, the division is going to be able to start snooping around into your business of the association if you're not compliant. And I will tell you, owners are going to make those complaints for sure. Okay, moving on. Websites. As of January 1st, 2026, a condominium association with 25 units or more will be required to maintain a website or an application on a mobile device that contains specified records for download. So folks, before it was 150, now it's 25 or more. You have to have a website. I think you should have a website even if you have less than 25, because it is an excellent way to do records management and move things along from board to board. But that threshold has changed and you need to be ready for it. In terms of official records, so Email addresses and fax numbers of unit owners are only accessible to other owners if consent to receive notice by electronic transmission is provided, or if the unit owner expressly indicates that their personal information can be shared with other unit owners. The association is prohibited from selling or sharing email addresses and fax numbers to outside third parties. If such information is included in documents released to a third party, the association must redact that information before the document is disseminated. And redact means take out a black Sharpie and remove it. An association is only liable if disclosure of email addresses or fax numbers was made with a knowing or intentional disregard of the protected nature of such information. That is going to be up to the trier of fact in terms of whether you were intentional or knowing about it. I think just your best practice is to make sure you remove those unless consent was provided. So, new records requirement, the association must maintain all invoices, transaction receipts, or deposit slips that substantiate any receipt or expenditure of funds by the association since the inception of the association. Now you may be immediately saying, how are we going to get those things since the inception? Well, this is effective July 1. So it's July 1 on. They're saying at this point, you cannot destroy any of those other things. They must be maintained. That makes sense. Start maintaining all of your receipts, invoices that deal with any expenditure of association funds now. The association must maintain a copy of all building permits and copies of all completed board member educational certificates. Being amenable. So official records must be maintained in an organized manner that facilitates inspection of the records by unit owners. So I put that on there and I'm laughing a little bit saying being amenable because here's a reality. In the past, you just had to provide the opportunity for an inspection of records, and literally some unit owner clients would go in and they're, here's a haul of boxes, good luck, right? Now they have to be maintained in a way that you can actually facilitate an inspection in an organized manner, which means you can't just say, welcome to the back closet and we'll see you in a couple hours. There's a good faith obligation to comply. So the official records are lost, destroyed, or otherwise unavailable. The association has a good faith obligation to obtain and recover those records as is reasonably possible. So I'm just going to give you the example of bank statements. If you're going to tell me you don't have your bank statements for the last 7 years, I'm going to tell you, you can get them. You can get your credit card statements. They're all available to you. Absolutely. You may not have them. Management may not have given them to you. The previous board, they didn't do what they were supposed to do. I get it, but you have an obligation to go and get those records. Now, if it is a bank from a 2 or 3 year, 2 or 3 relationships ago, that bank may have a policy where they no longer have that record. I don't know. I've seen it all in all different places. And perhaps Jamie could tell us a little bit about her policy on this one too, because every bank has a different policy. And I think you should generally have to try to do that. And then if you can't get them, give an affidavit stating you can't give them, which will come to the next slide and it'll explain to you how to do this. So the owner is now entitled to get a checklist of records made available for inspection. So you have to identify what you gave them and you have to identify what you didn't give them that was not available. So that's exactly what I'm saying, right? If you say, I want 7 years of bank records and you say, we don't have them, did you actually reasonably comply? Well, if you didn't go to try to get them, maybe you can't get them in the 10 days, but you can say, here's the checklist and we didn't give you this and it's going to be available then. But that checklist it's really a great, brilliant idea because it takes away the gamification of official records inspections and really makes it clear that we want all the records to be transparent and owners have a right to see them. The association can also respond to records requests by directing people to the website or their app that has the information, which I think is excellent. And really, they could have done that before, but now it's, black and white. So now let's talk about the criminal liability, all right, in regards to records. So if a director or manager knowingly, willfully, and repeatedly destroys or refuses to release official records and accounting records, they will be considered conducting a crime, and any person who engages in that activity would be removed from office and a vacancy declared. Repeatedly means 2 or more times in a 12-month period. That crime is a felony of the 3rd degree, and it is considered willful and knowingly refusing to release or otherwise produce association records with intent to avoid or escape detection, arrest, trial, or punishment for the commission of a crime or to assist another person. If the division, if the division gets a complaint, just like I said earlier, right, about the insurance, if they get a complaint about official records, the division may request access to the association's website or mobile app to investigate. So again, division's jurisdiction is really expanding, and we need to make sure things are tight. And I would also say to you, this criminal liability is really meant to make it clear that official records need to be made available, and there is a transparent environment in associations. Okay. Disclosure. All right. For the sale of a unit in a condominium, a unit owner must provide a copy of the annual financial statement and annual budget to be provided at the prospective purchaser's expense. Provided to the prospective purchaser at the seller's expense. My apologies. In reality, there is no expense here. The seller should have these, and they can request them as part of the official records. If they're in an association with more than 25 units, you'll be able to download this on your website, but you have an affirmative duty to provide it. If a unit is situated within a condominium created with a portion of a building or multiple parcel building, specific disclosures have to be provided for that sales transaction. So there's a little asterisk there if you need to know about that. And a developer must now include in the prospectus or offering a statement as to whether the condominium is created within a portion of a building within a multiple parcel buildings. There's a lot of changes, and I didn't include them all here. Again, I was thinking more about just residential, but if you're in a mixed use residential condominium, there are several tweaks that are very specific to mixed use. And I would absolutely have you speak to counsel, because it has made quite a bit of a change in terms of what is the condominium definition and the like. Okay, this is interesting because this is a shift. So this is strategic lawsuits against public participation. It's called a SLAP suit. Let me explain it to you, and then I'll give you my reasoning around this. So SLAP suits are legal actions brought against individuals for speaking out on issues that are important to the public. Condominium associations are prohibited from retaliating against unit owners through the use of various means, such as imposing fines, increasing assessments, initiating civil actions, including defamation or tortious interference. Condominium associations are prohibited from fining, discriminatorily increasing assessments, discriminatorily decreasing services, or bringing or threatening to bring an action for possession or other civil action, including defamation, tortious interference, libel, and slander. Florida statutes now provide that a unit owner can raise as a defense of retaliatory conduct, the unit owner must have acted in good faith and not for any improper purpose, such as to harass, cause unnecessary delay, or frivolous purpose, etc. So why is this happening? Because boards have used lawyers and they have used the law to push back on owners. So this is you see a little bit of balance coming out with this, and they're just making it really clear that owners have the right to talk about retaliatory action. And boards, I think, in my opinion, are just being put on notice in a heightened way that the statute's very clear you can no longer do this. So the statute specifically states examples of when a director or officer is prohibited from retaliation. So this is a really good way to think about it. So a unit owner has in good faith complained to maybe DBPR or your city. A unit owner has organized, encouraged, or participated in unit owner organization. So they got a group of owners together, which I've heard a lot about. Owners have submitted information or filed a complaint alleging criminal violation to either DBPR, Ombudsman's Office, law enforcement, etc. Unit owner has exercised their rights under 718, which would include things like inspection of records. They've complained to the association or association's representatives for failure to comply, or they've made public statements that are critical to the operation or management of the association. So the association may not use association funds to support such actions against owners. And the statute specifically prohibits the association from expending association funds to support defamation, libel, slander, or tortious interference against an owner or any other owner against a unit owner based on this conduct. So I again believe that this is a response to what perhaps legislators are hearing about associations coming down on owners. There's always like one headline that will, bring something up, but it's not. This is the 1%. Like I said, I think earlier, 99% of the associations are doing a very good job, but this is like the one bad apple that causes this. But at the same time, I think it's great because now we have a very, very clear example. And frankly, as managers and board members, you can remember this. And if you feel like you're ever on the edge of it, you can just, you know what, we should probably take a look because I remember that this is prohibited action. Okay. Pay attention, criminal sanctions. There's a lot of these, and I would say it has a chilling effect if you're committing a crime. If you're not committing a crime, okay, this just means, it's articulated and clear, but, again, 99% of everyone is doing a very good job. This is the 1%ers. So kickbacks. A kickback is anything of service or value for which consideration has not been paid or provided for an officer, a director, or manager for their own benefit or for the benefit of their family. If an officer, director, or manager knowingly solicits or offers to accept any kickback, they commit a felony of the 3rd degree and must be removed from their position and seat on the board. So it's just right off the bat, you will be removed and you will be now subject to a 3rd degree felony. For misdemeanors of the 1st degree, that deals with mostly voting violations. So again, voting violations, this is the 1%, but it does happen. So the following fraudulent voting activities are misdemeanors of the 1st degree. 1, willfully and falsely swearing to or affirming an oath or affirmation, or willfully procuring another person to falsely swear to or affirm an oath or affirmation in connection with or arising out of voting activities. Perpetrating or attempting to perpetrate or aiding fraud in connection with casting a vote, having a vote be cast or attempted to be cast. Preventing a member from voting or preventing a member from voting as he or she intended by fraud by changing or attempting to change their ballot, the ballot envelope, or the voting certificate. Menacing, threatening, or using bribery or any other corruption to attempt to directly or indirectly influence, deceive, or deter a member when the member is voting, and there is more. Giving or promising, directly or indirectly, anything of value for the intent to buy a vote. Using or threatening to use, either directly or indirectly, force, violence, or intimidation, or any tactic of that nature to have somebody vote a particular way or refrain from voting. Knowingly aiding, abetting, or advising a person in the commission of a fraudulent voting activity. Agreeing, conspiring, combining, or confederating with at least another person to commit fraudulent voting activity, and having knowledge of fraudulent voting activity related to the association elections, giving any aid to the offender with the intent for that person to just escape detection, arrest, trial, or punishment. Don't mess with the ballots. And if you are, again, I said this before, if you want to get together a group of people to help campaign and you want to support, I would be cautious and be sure that none of your behavior falls into these 9 categories. A director or officer charged by information or indicted with any of the following crimes is going to be removed from office immediately. And that would include forgery of a ballot envelope or voting certificate used in the election, theft or embezzlement involving association funds, destruction of or refusal to allow inspection of records, which is accessible to all owners within the statutory time limits in furtherance of any crime. That would actually be considered tampering with physical evidence. Obstruction of justice and any other criminal violation under this chapter. The board is required to fill that vacancy. While the director or officer has such criminal charge pending, he or she may not be appointed or elected to a position as a director or officer of any association and may not have access to the official records of that association except pursuant to court order. massive change, which is why I put that in bold. So if you have a pending charge, you're no longer eligible to be in the board of any association, and you cannot have access to those records. I've actually had situations where we had pending charges, and then there's a slew of inspection requests, and they're using that in lieu of discovery. It's been crazy. So I actually think this is awesome, but is a major change. Okay. Yeah, stop using debit cards. I said this in the HOA section too. Individuals found using debit cards for any expense that's not considered a lawful obligation are subject to criminal charges and automatically removed from office and a vacancy is declared. So the lawful obligation of the association is an obligation where it has been pre-approved by the board and reflected in the meeting minutes. If the division, again, note division's new authority, has cause to believe that an individual associated with a condo has engaged in fraud, theft, embezzlement, or other criminal activity, they will refer you to local law enforcement authorities. So division gets wind of it through a complaint, they are now required to go to the local authorities. So again, you could use debit card, but why would you with this kind of new legislation? If it's absolutely required, I think you and a good manager and even a self-managed association could figure out an opportunity to stop using debit cards to just stay away from any criminal liability. Okay. Let's talk about conflict of interest. So attendance of a director or an officer with a possible conflict of interest at a meeting of the board is sufficient for that board to still constitute a quorum for the meeting. Okay, so you still have a quorum and their vote, and the vote can still happen in their absence. So I've been asked this question a million times, and yeah, absolutely. If they're there for quorum purposes, but they would then, refrain from the right to vote on that particular subject that has a potential conflict. A contract entered into the association that is not properly disclosed as a conflict or potential conflict is voidable. So the idea, right? So let me take you back. You now have to have that meeting, your meeting agenda has to have that contract that's now attached to it. You need to disclose the potential conflict. It has to be in the meeting minutes. If it's not, the contract in and of itself is voidable. So all vendors, anyone that works in the association space should really take note of this. And they really should be looking at, is there any conceivable conflict of interest with any of our managers, directors, officers, owners, etc. And definitely get legal advice on that. Okay, let's talk about jurisdiction, division jurisdiction outright. So when the division of condominiums, timeshares, and mobile homes receives a complaint, the division's obligated to monitor the association's insurance coverages and may issue fines and penalties for the failure to maintain insurance policy and fidelity bond. I already told you that once, and now I've told you that twice. They have jurisdiction to investigate complaints related to procedural aspects and records pertaining to financial issues. These include annual financial reporting, assessments for common expenses, fines, commingling of reserves and operating funds, use of debit cards for unintended purposes, annual operating budget and allocation of reserve funds, financial records, and any other record necessary to determine revenues and expenses of the association. The division shall also have jurisdiction to investigate complaints related to elections, which they always have, including electing and voting requirements, recall of members, and elections that occur during an emergency. They should also have jurisdiction to investigate disclosure of conflicts of interest, the removal of a board member, any written inquiries by unit owners relating to such matters, including written inquiries in and of themselves. So I do want to make this pause. So there's an official records request component where you can do an official records request for inspection of records, but you can also do a written inquiry under 718. And there's a requirement that the board respond within 30 days and or identifies that they're seeking legal opinion. So that's the written inquiry they're talking about here. The division may issue citations and adopt rules. And these two changes, the bottom two are just sort of ancillary, but something I want to make sure you know about. The division director, employee, and condominium ombudsman may attend and observe any unit owner meeting or board meeting, including subcommittee meetings that are being held and are open to members of the association. So just take a step back. The division can come to any of your meetings now. That's what that means. The secretary of the division, rather than the governor, is the entity authorized to appoint the ombudsman, and that person no longer needs to be an attorney. And I have no opinion on that. I think that that's probably a good thing. Okay, I'm going to take a quick pause. We'll take a few questions, and then we'll get back into it because we've got another 25 slides.
Okay, so there's 89 questions, so 40 of them are new.
Okay.
And I'm going to start backwards here. Does the new condo law requiring posting of contracts mean that all contracts need to be voted on at a meeting, including switching, landscaper, or pool?
You bet. And all contracts should be voted on at meetings. I mean, I'll just say to you, the underlying of that question is all contracts have to be voted on at meetings. So yes, absolutely.
Okay. I think I know the answer. Debit card, credit cards are still okay for associations to use.
Yes, debit card is distinct from credit card.
Okay, a vote went out to owners for specific action. The vote came back to do what the owners agreed to, but the president decided not to do what the owners voted for. Is this considered fraud?
I wouldn't use the word fraud, but I'd say that's definitely the basis of a complaint, and I'd contact an attorney to talk about it.
As far as a member removal, what would happen if you cannot file that seat? It's hard enough to get board members now. Right, I think you meant
fill that seat, right? Yeah, no problem. Yeah, so if you automatically have to remove members, so let me just play it out for you. An association under 718 and 617 is required to have at least 3 board members. So as long as you have 3, you're not in what I would call receivership territory. So having at least 3 is good. If you can't find, it's an appointment. So what I would do is say, go to potential, neighbors and members of the association and say, look, we're going to appoint you for this period of time, and you don't have to run. And it's, whatever that short period is. I know it's hard, but the answer to your question is, as long as it doesn't fall under 3, I'm not concerned.
Okay. For the contract area that has to be added to all of the agendas, does that include the contract between the association and the managers? Does the owners get to look at the manager's contract before the board approves and extends the contract?
Absolutely, they would get the chance to do that. So 1, the manager's contract is now available. Absolutely, that's very clear. And yes, the owners would be able to see the management contract before. Correct.
Okay, for everyone asking, yes, a copy of the slide presentation will be sent out to everyone, including the questions that we're not getting to. Do the voting rules and penalties only apply to the board members, officers, and managers? Can they apply to owners too?
The voting rules and penalties. I think you're referring here. Do you mind? I'm just going to go back really quick. I think you're referring to fraudulent voting activities of the first degree. Yeah, these are voting activities that deal with actual board members and members of the association. I will triple check myself, but I am quite sure that that is the case. If you're referring to these voting violations, I believe that is the case, but I will, again, triple check myself and send it back.
Okay, so what you're saying is that the legislature is increasing the cost to 99?
No, when I said 99%, I was talking about 99% of the associations and boards are doing a good job. And it's like the 1% that did something wrong and created a headline that really resulted in what feels like a whole lot of regulation. I don't know about you and everyone else on this call, but this is a whole lot of regulation around condominium associations right now.
We have an owner who requests to review records a couple times a year. We recently told this owner that all records requested are on the website. Owner is now saying we're not complying with the new law by providing an owner a space and copies for review. Are we obligated to do this if the records are available to view on our website?
Yeah, I would say no. I think the statute's pretty clear. You could absolutely send them to the website. And what I would do is put that in writing and quote the statute.
Okay. Is there a materiality level of definition of a contract versus just an invoice or normal course spending on R&M?
That's a very good question. So you're absolutely right, because in the association world and in my experience, I've also had, what people have said is a contract looks like a request for proposal. It looks like a proposal or an invoice. I'm going to tell you to go that, my opinion is to always give advice to be on the conservative side. And anytime you're voting to expend association funds, whether it's the contract, and the statute does say invoice or other documentation should be attached, you need to attach it. I wouldn't get caught up in, is it a contract, is it not a contract? If you're making a decision to expend association funds and that decision is being made at that board meeting, that needs to be included. That's what I would do.
Retaliation. How does a board member or board defend itself against an action that isn't retaliation?
Yeah, that's a really good question, right? So the SLAPP suit is meant to be, it's a retaliatory, it gives a cause of action and an actual defense, right? So the SLAPP suit is a prohibition, and retaliation is a defense by the person you're going after. I think you speak to your attorney about the specific situation. It's not meant to say a board can't go after somebody. There's still going to be those situations. I think this is just giving more clarity that we need to be sure that there isn't any sort of underlying discriminatory, harassing behavior coming from the board. Best thing to do is to talk to your attorney, very fact specific, but you still will have the option to go after owners. I mean, that's definitely still an availability. I think they're just making it clear that they don't want boards to weaponize their power.
Okay. What's the difference between a portal and a website?
Yeah, well, so the website is forward facing. So when they talk about the website, they need the website to have a forward facing public side. And then the portal, I think, would be what we would consider the access. So private access to unit owners and other unit owners in the board to look at specific documentation. You can also use an app. So the terms that are being used right now are website and app, mobile application, and the idea is that you'd be able to download documentation from it.
Okay, and you already mentioned that third-party property manager portals do not meet the website requirements. So a website is still required.
Well, you need to. So I actually have a checklist, and I think most of us attorneys have checklists now on how the websites work. You need to work. You don't just want to say the third-party portal is not going to work. Most of them were not designed for that. So you need to have a conversation with your management company and make sure it meets those requirements. They're all looking at it now. But you just need to have that forward public facing side and then the ability to have password protection.
Okay, and people are asking for that checklist, of course,
Okay, cool.
if you have it available. Does the phone number need to be redacted on an application provided to the board for approval? Is the board considered a third party?
The board is not a third party. The board is not a third party. When we're talking about third party dissemination of information, that would be to a unit owner who's doing a request, the division who's requesting documentation, law enforcement requesting documentation, other third parties, maybe a vendor needs a list of unit owners so they can determine where cars are, etc. So the board is not considered a third party for that purpose.
Suspending voting rights. Can a delinquent notice include a disclosure that states voting rights will be suspended for delinquencies that exceed 90 days?
Well, you have to give them notice that you're going to suspend their voting rights. The law says you can only suspend those voting rights if they're delinquent 90 days. So I don't know if that's exactly the terminology you're going to use. I think you should have you're going to send them a notice and say you're over 90 days and we may suspend your voting rights. That can be put in there, right? But you must do that within 90 days of the election is what the new law says. So I wasn't quite sure, and I apologize, wasn't quite sure if that was what was said, but yeah, you can put in that disclosure to make sure whether it checks the mark on the statute. Just make sure your attorney gets their eyes on it really quickly and gives you the thumbs up.
Okay.
One more, Beth, and then we're gonna roll
one
on.
more. Okay, and then you only have 86 more.
Okay.
Records requirements. No termination date for retention. IRS has a guideline.
So the statute says 7 years is what's required, and some portions of records need to be kept even longer. So 7 years is what it says. I believe that our milestone and section reports, I think those are actually 10 now. It's not a part of the new statute, it was last year, but 7 years is the minimum that has to be kept. Okay, we good for now?
We're good for now, 86
Okay.
more.
Okay. Well, maybe what I'll do is I'll try to see if I can stay on for a minute, but we'll download all the questions and I'll take some time tomorrow and on the 4th of July to get them answered for everybody. Okay, so let's move through it. Thank you again for your attention. So changes to the law for community association managers that impact how the association and board works with them. So first, managers and management companies must return records within 20 days after termination, okay? If they fail to timely return all of those records, there is a presumption created that the manager has willfully failed to comply and subjects the manager or management company to a license suspension and a potential civil penalty of $1,000 per day for up to 10 business days, beginning on the 21st business day after the earlier of the termination of the management agreement or a written receipt of the request of the records from the association. First of all, this is a massive change and super important that you understand you can get your records back. And I think this is what this is telling us. Okay, conflict of interest disclosure. If a new conflict of interest disclosure requirements for managers, a manager is required to disclose to the board of directors any activity that may be reasonably construed to be a conflict of interest. There is a rebuttable presumption that there is a conflict of interest if the following occurs without notice. A manager or an individual with a financial interest in a management firm or relative of such a person enters into a contract for goods and services with the association. Or two, a manager or an individual with a financial interest in a management firm or the relative of such person holds an interest in or receives compensation or anything of value from a corporation, LLC, partnership, or other business entity that conducts business with the association or proposes to enter into a contract with the association. So what this means is the conflict of interest threshold has very much increased, or maybe I should say it's decreased, because any perceived conflict has to be disclosed. So in the past, managers may have had, lots of different vendors that they work with. Well, you then find out that the vendor is owned by their brother-in-law, their sister-in-law, that kind of thing. That disclosure has to happen, or it's presumed that it's a conflict. So now, there's also a multiple bid requirement for managers. So if an association is going to solicit multiple bids from a third party, if it receives and considers a bid to provide goods or services from a manager that exceeds $2,500. So if a manager or their relative proposes to engage in activity that is a conflict of interest, the proposed activity and all contracts and documents relating to the proposed activity must be listed on or attached to the meeting minutes of the next meeting agenda for the next board meeting. So just like the conflict with the board of directors has to be disclosed, this has to be disclosed. The disclosure of any possible conflict of interest must be entered into the meeting minutes. Approval of the contract requires 2/3 of all the directors present. And at the next members meeting, the existence of the conflict and the contract must be disclosed to members. This is very similar to the conflict of interest section that is currently in the statute and how you deal with conflict of interest. What this means to me is that managers just have to understand they're going to need multiple bids if they want to provide services over $2,500 themselves. And if they have a conflict with a relative or relative that's providing services, it must be disclosed. Again, not a problem. You can do it. It just has to be done properly. So what happens if a manager violates these provisions for disclosure or otherwise? If the contract is canceled, the association is only obligated to pay for the reasonable value of the management services provided up to the time of the cancellation and is not liable for termination fees, liquidated damages, or any other form of payment. If the association enters into a contract in violation of the statute and fails to provide the requisite disclosures, the contract is voidable and terminates upon the association filing a written notice terminating the contract with the board, which contains consent of less than 20% of the voting interest of the board. Bottom line, association may cancel its agreement with the manager. So on that note, let's talk about how you're going to have to increase your board of director continuing education requirements. So currently you have a 2-hour board member certification course. That is now moved to 4 hours and includes milestone inspections, structural integrity reserve studies, elections, record keeping, financial literacy, transparency, levying of fines, and notice requirements. Each newly elected or appointed director must submit to the secretary of the association a written certification and educational certificate within 1 year before being elected or 90 days after the election or appointment. Directors are elected or appointed before July 1, 2024, must fill out these requirements by June 30th, 2025. So that specific language around fulfilling them by June 30th, 2025 is in the condominium changes. And I was asked this question in the HOA side. And if it's not specified, my hunch is we're going to still follow the same requirement. Now, what changes also is that your educational certificates remain valid for 7 years from the date of issuance and do not require resubmission as long as the director serves continuously on the board. Directors appointed by developers can fulfill these requirements. And then all you need in a condominium is 1 hour of continuing education related to the laws every year. If you were on for the HOA side, they need 4 to 8 hours of continuing education. In a condominium, you only need 1 hour, and it is only about new laws. So it's a very different educational requirement. Also, I may have breezed over it a little bit, but you have to do the course and a written certification. It is not an either or, it is a plus now. So you must do both. Okay. Let us go to the next section. So we just went through basically Condo 3.0 bill. And now I'm going to take us home with the rest of the legislation. So the My Safe Florida Condominium Pilot Program, I just did a webinar on this myself last week. It's a new pilot program created by the state and executed by the Department of Financial Services. There's $30 million that's been allocated, and it's subject to annual appropriation. So this is just a pilot program. It provides both hurricane mitigation inspections and grants. And grants require matching funds by the association and there are limits on the amount of money available depending on the project. There is no entitlement for this. This is a pilot program. You're going to have to apply. And I'll tell you, this legislation is effective now. I just sent out before this webinar, the Department of Financial Services issued a statement saying that the forms and disclosures that are required in this grant process and the inspection process are not going to be available till the fall of this year. So despite the fact this is effective now, they've got to implement it, and the appropriations were just made, so they're doing the work now. What condominiums are eligible, you may be wondering to yourself. Well, any condominium that is 15 miles inward of the coastline. So this means the low water line along the portion of the coast that has direct contact with the open sea, and the link marking the seaward limit of inland waters. I actually put that in there because there was a lot of talk about what is coastline a couple of years ago, but it's 15 miles inward from the coastline, you are eligible. To participate, you can either apply for an inspection or a grant, or both. The board must receive approval by a majority vote of the board or a majority vote of the total interest of the association to participate. It's an or, and I'll explain why. The vote by the total voting interest of the association may take place at an annual budget meeting or unit owner meeting. And before a vote may be taken, the association must provide unit owners a clear disclosure of the pilot program created by the department. And that's what we don't have right now. So you really can't take any actions. The president and the treasurer must sign the disclosure indicating that a copy of the form is provided to each owner. And then within 14 days after an affirmative vote to participate in the pilot program, the association must provide written notice in the same manner to all unit owners about the decision to participate. So the first move is to do the vote by the board to say we want to participate in the program. That is all that's required for the inspection. If you're going to get into the grant territory, that's where the majority of the total vote of interest of the association is required. I put here already, it's anticipated that the program applications will not be publicly available until the fall of 2024. And these are the websites that you can use. It's coming out of the CFO's office, the Department of Financial Services. And under that, you will see that there are links available for you. So the last piece of legislation we're going to cover is the new squatters' rights laws. So there's new procedure for property owners to request that a sheriff remove an unauthorized person from residential real property. So in this situation in a condominium, if you have leased out your unit to someone, this would not apply to you. If it's an immediate family member, this would not apply to you. This really truly is a squatter situation. So in order to file a complaint with the sheriff, you have to be the requesting person has to be the owner themselves or the authorized agent. The real property has to be residential in nature. The unauthorized person must have entered unlawfully and continues to remain at the property. The real property was not open or available to members of the public at the time that the person entered. And the property owner has actually directed them to leave. And again, they cannot be former tenants either by written or oral agreement, and they cannot be immediate family members, and there can be no current pending litigation to go through this process. So if you're eligible, the sheriff can verify it and remove the unauthorized person, but you are going to be paying the sheriff the civil eviction fee plus an hourly rate if you're requesting them to stay to see that the contents of the unit are taken with that person. On the flip side, if you use this improperly, then the person that's been wrongfully removed can get 3 times the fair market rent, damages, costs, and attorney's fees. So use it, be careful before you go down this road. There are 3 new legal causes of action. So a person who unlawfully occupies, detains, or trespasses and causes more than $1,000 in damages commits a felony of the 2nd degree. If you make a false statement or provide a false statement and purport that a lease is valid or a deed is valid or any other instrument is valid, that's a misdemeanor of the 1st degree. And a person who lists or advertises property knowing that the seller has no legal title or authority or otherwise rents it with that same knowledge commits a felony of the 3rd degree. So there's a lot of opportunity here to support property owners and their rights. I think it's actually great, but I would just be cautious. And if you are in real estate, if you're maybe a real estate agent or in that space, these causes of action I think are quite interesting and useful to know. Last thing, just because I thought it was interesting, was also included in Condo 3.0. The Florida Building Commission is undertaking a study focused on water intrusion through tracks of sliding glass, which is actually something you may be like, oh yeah, that's exactly where water comes in through. So they're doing an evaluation now, and they're going to be required to submit a comprehensive written report. So the reason I share that with you is coming attractions, maybe 2025, we'll see some legislation around the impact of that. So I am right under the gun. I want to thank you all again for being on. If you stayed on for the whole time, bless you. And if you were just here for one segment, great. This is being recorded. We are going to send the slides, and I'm going to do my best to answer just maybe, how about just 2 more questions, Beth? And then we'll wrap it up because I do want to end on time for everyone, and then we'll take it to the next time we all get together.
Okay. If your condo only has 2 stories, do you have to do the SIRs? Anything else? Well, I know the buildings 3 or more stories have to.
You answered it, Beth. Yes.
So, let's see. Let me go back at a good one here. As a manager, do you need to disclose if a relative works, does not own or get commission for a business that the association does business with? What if the association hired a contractor before the family started working for the contractor?
Yeah, I think that's a really good question. I think when I look at that statute, they're looking at having financial interest, and that would include, so I mean, usually it's not just remuneration, like just getting paid. It's like you get a financial benefit. I would disclose that. I think at this point, and the way that the division's looking at it, they want that disclosure every time. And if it happened before this legislation, just make the disclosure now. And I would also seek association counsel's perspective on that, because if they say we don't think you need to disclose it, then you can then rely on that. You can rely on that opinion that disclosure wasn't necessary.
Okay. What if the association has an outstanding invoice like $67,000 and the association refuses to pay and terminated the management company? Does the management company still have to return the records?
Oh, that's a really good question. So the way the new statute is reading, you're going to need to return those records whether or not they owe you money. It's not going to be a defense. I think the idea is records have been weaponized, right? And I understand it. Like, I haven't been paid. I don't want to give you my records, but you really should take up that cause of action as a breach of contract and sue the association for the 67,000. And at this point, turn over the records. I mean, that's why that statute changed. They want the records to shift. We can't hold on to them. And if you think about it also from this perspective, like widen back, we have all of these new website requirements. And why do we do that? Because so no more of this weaponization of records. Like everything should be available. And that's also why with websites, you know, third-party vendors, that's great, but the association has to maintain control. So, all right.
This is a great question. Do you have one more?
We'll do one more. We'll do one more at the top of the hour.
Is there now a requirement for board members to file a financial disclosure report that becomes a public record and available to anyone? Some area communities have a council members resign over this law. Does it apply to COA board members?
Yes, it does. It's called the Corporate Transparency Act. And unfortunately, that is in place. There was a appeal done and it's still in place. I'll tell you that the Community Association Institute, which is called CAI, it's an umbrella organization, has actually filed a lawsuit in federal court to seek an exception for associations. But as of now, the association is responsible for submitting under CTA, Corporate Transparency Act. And it would probably be a great sort of shorter webinar that we can do, Peggy, just to let people know what needs to be done. I like a good 30 minutes. This is what you need to know. And yes, people are resigning over that. Completely understand why. Completely understand it. So. Okay.
Great.
So again, thank you all. I super appreciate it. One thing I'll just point out is dearcondoboard.com is a place where you can ask questions, or you can send it to unit owners to ask questions. I won't give specific legal advice, but I will point you to the statutes and help you try to resolve things. So if you have any questions that you want to send over to me, you're welcome to do it either at Dear Condo Board or just reach out to me directly. Again, thanks to all of our sponsors. You guys are great. And I can't believe I talked for 2 hours.
We can't either.
That's a lot of talking, Jane. Great job.
All right. Peggy, you want to close us out?
Yes, yep. So real quickly, I don't know who got off and who got on, so we're going to quickly run through our sponsors for today. We had Vinteum Software, Brown & Brown Insurance, the Reserve Advisors, Benjamin Moore Paints, Best Roofing, RMS Building Envelope Consultants, DSS Condo, a division of Socotec. We had United Professional Engineering, Hafer Company, First Citizens Bank, Altieri, and Beach and Patio Outdoor Living. I just want to say thank you also to Jane, outstanding, all the sponsors. I want to thank the board members whom I commend for being on the class today or the course today, the CAMs who as well for attending and receiving your license, or not receiving your license credit, but diligently working for your associations on and off the clock. So have a great 4th. Everybody be safe, and we hope to see you on the next webinar. Yes, thank you. I forgot to mention when they were real quickly. August 6th. I'm sorry, July 16th, I have the 2023 update so that you can get 2 credits on your license for the end of this year by Rosenbaum PLLC. I have Bruce Wingfield from Salis O'Brien coming in and talking about before and after milestone studies. I have Casper Electric coming in, keep the lights on. They're going to talk about electricity issues at condominiums. On 9/4, we have Stephen Rappaport. He's with Sachs and Kaplan on the covenant enforcements. And that's it. Thank you.
Awesome. Thanks.
That's it. Bye.
Bye, guys.
Everyone have a great day. Thank you so much.
Bye-bye.